For the record, this is the second case on our oral argument calendar, Seth Connor Wells versus State of Florida. Is the appellant prepared to move forward?
We are, Your Honor.
Please proceed. And before you do, how much time would you like for rebuttal?
Well, in deference to my honorable colleague, I'd like to split it half and half because I know he's going to put the fire on me, so I'd like to have enough reserve time for rebuttal.
Okay, so that would be 10 minutes.
If I get 20, that'll be 10. Thank you, Your Honor.
Thank you. Please proceed.
Yes, Steve Gosney representing Mr. Wells. And this case is Mr. Wells was put in prison for a series of felonies. He was then had a tail end of probation. And then one of the conditions of probation was that he not dress up for Halloween in a costume that appeals to children. And then also another provision was he had a 10 p.m. curfew. He was found to be violated for those two violations, and for that he received 22 years in prison, as well as a $400,000 cost of incarceration. I'd prefer to focus on point 3, which is the constitutionality of the cost of incarceration for the purposes of oral argument. The cost of incarceration it has not been tested in Florida constitutionally.
Before you get there, counsel, and we can certainly get to that in a minute, but as to the point about the violation of probation, did I hear you say, because I don't necessarily see this in the order of probation, that there was a prohibition on him dressing up at Halloween? That's not the way I read that provision of the order, but maybe I'm mistaken. So
No, actually, you're absolutely correct. And one of the questions here is, do we read this order carefully as lawyers and strictly as a probationary order, or do we read it sort of loosely and say, well, it's just a Halloween costume and whatever it is? I would expect this court and law generally to be very strict with the reading of the probationary order. And if you read that, it lists a number of costumes that are not allowed. For example, Santa Claus, Easter, and then in the Halloween context, it's basically all of these things. The one, in order for him to be violated, has to show that it appeals to children. And then there is also an additional modification. If you read it carefully, it says, and passing out candy and Halloween-type activities.
Well, and I'm looking at 44B. This is the probation order. It says a prohibition on distributing candy or other items to children on Halloween. I don't see any other reference to Halloween.
Right.
Am I missing something?
No, you're absolutely correct. And in fact, there is no allegation at all that he was passing out pop candy. And that's an and. So if you read it in, that would defeat that probation violation in and of itself. There's also no...
To be clear, he was not charged with violating that particular condition. Let's see, he was charged with violating condition 9, which was not following the probation officer's orders implementing that condition. Is that correct?
Well, and it's interesting, it's very sloppy the way that this kind of came out into the court. I tried to clarify that with a B2 clarification motion to make clear what was being violated. Yes, I would say that the statement of the officer was that he was not violating the explicit orders of the probation officer. However, you've got the order itself. So did he violate the actual probation condition? Well, it was not a costume that appealed to children. He wasn't passing out candy.
What did the order itself say? What condition did the order itself say he violated?
It's in the brief. It's basically he must be dressing up as a costume to appeal to children, and then there also the subset for the violation is
what number prohibition did the order say he violated?
I'm sorry, repeat that.
What number violation did it say? What number prohibition did it say he violated?
Well, it was violation of probation order 9 and 15.
And what is 9?
Well, 9 is failing to comply with all instructions given by the probation officer. And he was instructed not to engage in Halloween activities, i.e. wear a costume, and the offender did not fail up instruction. He dressed up as a devil, and he was at work at Denny's serving people at Denny's in his devil costume. However, the question is, if the officer, I mean, there's a lot of confusion here, because if you read the statement of during the,
In line with what Justice McIver just asked you, again, sub 9, I can only read what's in front of me. It says, you will comply with all instructions your officer may give you. Do you concede here in front of us that he did not comply with all instructions his probation officer gave him?
no, I would not concede that, because there is confusion as to what was ordered and what he actually did. If you read the testimony of the officer's testimony, that's what the allegation is in the violation. But what the officer says he actually instructed my client, she said, Halloween such as passing out candy, and that's an and. So based on the testimony of the officer, her order was not violated by what he did. The substance of what he did was dress up as a costume for his workplace so he could earn extra tips. It was not to appeal to children, and he was not passing out candy. So if you read the testimony of the officer in the actual violation hearing, her order was different than what was alleged in the violation itself.
Do you have any argument that he did not violate his curfew?
Well, he had a 10 o'clock curfew. Now there's some questions, and I don't. The facts are, he was trying to get his probation modified so that he could work later.
But it was not yet modified.
It was not yet modified.
And
That's
so
correct.
therefore 10 o'clock still applied.
That's true.
And he's at 10:30.
That's true.
And his manager said, I tried to adjust the schedule, et cetera, but his probation was clear. The order was clear, not ambiguous, right?
Yes.
He was at Denny's at 10:30, 30 minutes after his curfew had expired, correct?
Correct.
Is there any basis by which it cannot be determined he violated his probation in a material way, willfully?
Yeah, well, there's willful and substantial. Okay, so we have both of those prongs.
Curfew is substantial under Florida law.
Well, the
Even
question-
if considered technical because it's not a new law violation. I mean, the cases are legion.
Sure.
That a curfew violation is substantial, are they not?
However, isn't he also under an obligation to maintain gainful employment? And wasn't he also put in a situation where his immediate supervisor, as an employment, said, you must stay in this job, you must clean up, or you will lose your job? That's clear from the record. And the fact is that the probation officer herself even said that she was supportive of the change. So my client is in a position where if he walks off the job, he loses his job, which is then going to be a violation. He's put in a catch-22.
Okay.
So, that's a willful and substantial violation. You have to have both of those things. Is that willful? Well, he's put in a situation where he has no choice. He's under these countermanding authorities. And what's the best decision? He'll walk off and lose his job.
Why not call the probation officer and talk through with her? I've got a client here.
At 10 o'clock at night?
That's right. Well, 9:30. I mean, couldn't he have appreciated where this is headed? And I've got a problem. I'm likely going to lose my job if I leave at 10. Help me understand. Wouldn't that have been the right course for your client?
Well, assuming that a government employee would answer their phone at 9:30 at night, and also assuming that
Well, she was working.
she was working because they do these sweeps on Halloween, which I found out from this case is fascinating. Yes, that's true. However, he also has this there's a lot of conversation, there's obviously a lot of history between my client and the probation officer, and they were of the understanding, even though it was not explicit, and that's part of the problem, one of the reasons he was violated, is because the probation officer says he wasn't taking it seriously enough, but they were having a discussion amongst them that they were modifying the probation, and she was supportive of that. But, and in fact, the probation officer only wanted to change this to community control. The judge is the one that imposed the 22-year sentence and the $400,000 cost of incarceration, which I would like to address.
So, but the judge is certainly not bound by the recommendation of the Department.
That's true.
And it may well be the Department of Corrections, and I can't recall the testimony of the record in this particular case, but that may be a standing practice is to recommend kind of a level increase of supervision. But ultimately, the judge is free to impose any lawful sentence under Florida law, is he not?
Yes.
22 years of lawful sentence?
Yes. The cost of incarceration, it's a $50 day. This has never been addressed by a court in Florida. And the excessive fines clause goes all the way back to Magna Carta, which is still law. And in fact, this cost of incarceration is $400,000. That exceeds his lifetime expected earnings upon release. So, and Magna Carta itself, and Blackstone comments on Magna Carta, that a fine cannot exceed somebody's ability to live and thrive as a human being. If he has to pay,
You said fine.
Fine.
There is case law that says cost of incarceration is not a fine, correct?
well, and that's the question. The excessive fines clause is examined under, and I'm going to have butchered the name. It's Bajikakan, U.S. Bajikakan.
I'm a butcher too.
I'll go with that one. And the Bajikakan case, which was a Clarence Thomas decision, analyzes the excessive fines clause. And the two-pronged question is excessive and is it a fine? So those are our two operative inquiries. Excessiveness is clear based on what I just said. The amount of this fine exceeds his total lifetime expected income upon release. So it's excessive. Then the question is what Your Honor brought up, which is it a fine? And that is only if it is in some part punitive under the Bajikakan case. Is it in some part or portion punitive? And in this case, that fee is only generated upon a conviction of a crime. So, in fact, restitution itself is also designed under, I think it's the Knoll case that's cited in the brief. Restitution itself is in part punitive. So I think it is a fine and it is excessive. So it fails. And I would also point out that Your Honor's, legislative deference is a thing. And I know that the court is very sensitive to legislative deference in these type cases. However, this is the type of case where there should be a lot less deference, and Blackstone talks about this in his commentaries. And when you have the state, which is gaining from this punitive type punishment, then there needs to be extrajudicial or less judicial deference, extra scrutiny, especially when we're talking about a fundamental constitutional right, excessive fine, that applies to a citizen, where a citizen, which my client is not a politically popular citizen, is not going to get redressed from the political things. We represent an individual. The Constitution itself is meant to shield individuals from overarching majority state action when they're in an unpopular class, of which my client is. So I would really urge Your Honors to look at this with very strong scrutiny. And so the question is it a fine? Is it excessive? Yes on both questions, therefore it must strike. Also, I would also say that...
And I understand you collectivized it over the course of the 22 years, but $50 a day seems like less than the state of Florida would pay to house your client. Is that not the case? I mean, and as I understand the case law on that, those types of expenses were validated 20 years ago, even with inflation. So is the daily excessive?
Well, and that's a very good point. And in fact, I addressed this in the proportionality section. I'm not sure if it's point 3 or point 4. But Your Honors don't have to decide in every particular situation. Proportionality is a fuzzy concept. What the court is called upon is to find whether in this case, in a case-by-case basis, whether it is an excessive fine as applied in this case. And when the hypotheticals, we can come up with a million hypotheticals. And when you apply a proportionality analysis to it, those hypotheticals may rise or may fail. That's not the court's question to be answered. The court has to answer the case that's before it, and that's Mr. Wells's case. And Mr. Wells's case is 22 years in prison, $400,000 plus in fines. Is that excessive? Well, I understand that, but the net, the aggregate is total is $400,000 plus, and that's the case that's before the court. So how are we doing time?
Well, you've got about 6.5 minutes left. Would you like to reserve the rest for rebuttal?
Yes, thank you, Your Honor.
Thank you.
May it please the court, for the record, my name is Dan Caldwell. I'm the Attorney General's Office. I represent the state of Florida appellee in this case. Your Honor, it's the state's position that the trial court's decision to find a willful and substantial violation was supported by substantial and competent evidence below. There was no disagreement on the testimony as to the violation. The real argument seemed to be that it was either a difficult decision or it was a de minimis violation. Starting with the curfew, no one argued he was not at his house. Both probation officers testified.
Can I lean in a little bit, just, and
Yes,
when you jump in too early, I apologize, but on the violation,
Yes, sir.
failing to follow the probation officer's orders. Hypothetically, we know he had a curfew of 10 o'clock. Let's say the probation officer had ordered him instead to be in by 9:30. Clearly, the probation officer doesn't have the authority to change the terms of his probation or add new conditions. If that was what we were facing here today, we wouldn't be able to uphold it, would we?
No.
So, given the text of the prohibitions in his order, and that he wasn't wearing one of the prohibited costumes around the holidays that had prohibited costumes, is it fair to say that an order from a probation officer adding an extra term of you will not wear a costume on Halloween would be outside the bounds of what they would have the authority to order him to do?
No, Your Honor, because first, returning to the original hypothetical, let's say a probation officer said, I don't care that your order says 10:30, you're going to be in by 9:30. It would not at that point be proper for a probationer to just stay out till 10, or maybe he will. Either way, it's going to come before the court, and the probationer can say, Your Honor, you told me I had till 10. The probation officer changed this on her own. She doesn't get to do that. It would not be incumbent upon the probation officer, the probationer, to determine what rules he's going to follow and what rules he's not going to follow. Likewise, the modification that the probation officer made in this case was in the spirit of the rule, and you can look at it a few different ways. It's not, I've seen probation officers, I was a prosecutor for a long time, I've seen
If we're to go down the road of the spirit rather than the text, it's probably going to be a high bar for you.
Yes, I understand that, but the spirit, well, I understand, so I won't say the word spirit again, but I've seen probation officers who have gone after probationers. I've also seen probation officers who have looked out for probationers. Personally, if I was a probation officer, I'd say, you know what, don't worry about whether or not the costume appeals to children. Let's just solve this right now. Don't wear a costume, and you will never be sitting in court wearing a costume, and we will be discussing, do kids like this or do kids not? But again, back to my original point, even if the probation officer was completely wrong, it still was not up to to appellant himself to make that determination. He could have set a status hearing, called his public defender, those happen all the time, and say, okay, my probation officer judge is telling me I can't do all sorts of things that Your Honor didn't order. I don't think she has the authority. I'm seeking a review of that. It's not up to appellant to decide what rules he will follow and what rules he will not.
No, but if there is an error on the part of the probationer and they didn't follow the rule when it gets to the court can't say that you violated this condition if that condition wasn't authorized in the first place. Am I correct there?
If it was not for a substantial violation, I would argue yes, Your Honor, but I don't. A probation officer is the order specifically said, follow all orders of your probation officer. I understand where this is going to be splitting hairs, but the probation officer did give an order, and it was not a substantial modification. It wasn't the changing of the curfew. It was ultimately saying, do not participate in Halloween activities by doing the following. Don't wear a costume. Don't pass out candy. That was the order. And the trial court's finding was not that, okay, you wore a costume and that's why I'm violating it. Even though he talked about it, he said you didn't follow the order. And the trial court pointed out, he took this on a case-by-case basis. He put it in context. He said, listen, there was testimony. Some people thought you were wearing devil horns. You said you were wearing a hat with devil horns. Some people said red glitter paint. You said red paint. Maybe a cape, maybe a blouse. That's not the issue. The issue was you weren't supposed to participate in Halloween activities, and you did by wearing a costume. And that was the order that was violated.
I won't enough last time. Let's hypothetically say that we were to find that there was a violation of the curfew, but there was not a violation of the order provision. The court would have been, just on the curfew violation alone, able to impose the penalty that did.
Absolutely, Your Honor.
So would it be incumbent upon us to remand to the court to say it was 2 instead of 1, maybe you ought to reconsider the significance of the penalty, or would it be incumbent upon us to say that it wasn't an error in the penalty, we shouldn't remand?
If my choices were remand to find one penalty and reconsider the second one, or to consider all of them, of course, I would say the court's better option would be to remand only on the condition 9 violation. The condition 15 violation, the curfew, that was clearly a violation. And to hit on that point briefly, I know there was some argument that he was in an impossible situation. I have to point out that the appellant put himself in that situation. Every probationer, whether they have a split sentence or they go straight to probation, they're told one thing in court. The judge says, when you leave this courtroom or when you leave prison, you go to your probation officer, they will instruct you on the terms. Appellant did so in this case. He was told, this is your curfew. He tried to modify it, but the probation officer specifically testified, I told him, you had a motion out there, but you still have to be in by 10. Knowing that he had a curfew between 10 p.m. and 6 a.m., and knowing that he'd gotten a great downward departure on a very serious sentence, he was looking at 35 years. He scored 6 years. He got 2, followed by probation. He then went out and found a job that would interfere with his curfew. There are many other jobs out there that are not restaurants. There are also restaurant shifts that don't push down to 10 o'clock.
Let me ask you this, Mr. Caldwell, and again, looking at the conditions in the order on probation, sub 8 says you will work diligently at a lawful occupation. Is there a tension here between that and what happened to him as far as violating the curfew? I mean, obviously, this point is, I'm working diligently in my lawful occupation. His manager comes in and says, if he left at 10, he's going to get fired because he's the only server on duty. Why is that not a good enough thing, perhaps, in that unique circumstance to trump the curfew?
Well, just referring back to my earlier argument, the appellant was in that position because of the choices he made. Again, he knew when his curfew was. He went and found a job where they said, these are your shifts. There are other jobs out there, or even different restaurant shifts he could have taken. But also, it's a question of which authority are you going to obey. An analogy for myself, when I was still living with my parents and I was in high school, my father always made it very clear, I can work on weekends, but never on a school night, and never past 8 on a Sunday night. And my father was not a spare the rod kind of guy. And on numerous occasions, I was asked to work past 8 o'clock. I risked my job and never did because I had to pick which authority to follow. If appellant is in a situation where, first of all, he knew his curfew was, he goes and he gets a job where he knows he's going to be pushing the boundaries of that curfew, and then he's told, if you break this, you're going to get fired. His choices are, do I have a substantive violation and I break a curfew, or do I just possibly lose my job and I explain the circumstances to the court? If I have to choose between obeying the court or the manager at Denny's, I'm going to obey the court. Would be my answer to your question on that.
And to Judge South's point, is it a false dichotomy anyways? He had a phony could have called it probation.
Yes, Your Honor. And again, all the case law cited by appellant, he never made an effort. There was, in the record, it's difficult to convey tone in written words, but there was a nonchalance in appellant's testimony about his violation. He talked about his prior probation officer giving him breaks because she knew he wasn't a criminal, or words to that effect. He never attempted to call. He knew he was working late. This is the only violation of the time he was caught violating curfew. There was a subtext in there where I think it had happened probably on other occasions. All one has to do is at least try and call. And because the case law says the courts must analyze each violation on a case-by-case basis, I think the result, the court could have utilized its discretion, and the result might have been very different if appellant could have testified, yes, I was threatened with being fired, I called my probation officer, I left a message, and if the probation officer said, yeah, he left a message. There's all sorts of case law where people they were about to violate, they call their probation officer and they say, hey, I'm in trouble. The Downs case actually cited by appellant himself, or appellant's counsel, where somebody was going to violate curfew. I'm sorry, the Downs case he did not call. I'm thinking of the Hearn case. When the court found somebody made a substantial step to attempt to comply with conditions of their probation, then that's usually held to be a violation. But there were no substantial steps here. He just said, I'm going to work late, and it wasn't until he was discovered that he gave an explanation. Moving on to, I don't know if your honors have any further questions on the violations. I would like to address some of the fines analysis. All right. So, first of all, I have to argue that this is clearly not a fine. This has been decided legally. One of the cases even cited in appellant's brief, Buchanan versus City of Fort Lauderdale, and that's been cited by this honorable court. I did make a mistake in my brief on the site itself. Chapter 960 has been analyzed before. It's true that the county court in Buchanan said, okay, this shocks the conscience, it's an excessive fine. Florida Supreme Court disagreed and said, no, this is not an excessive fine. So, or it's not even a fine. This has no bearing on a fine because under the Freeman case, the court stated that just because something can be applied in a criminal context doesn't mean it's a punishment. $50 cost of investigation versus $50 cost of prosecution. I don't know if that's actually a punishment. Here, as the court pointed out, this is a damages statute. These are damages. Chapter 960 allows victims to recover damages for violations for damages suffered as a result of someone's violation of the criminal law. And in this case, the state is entitled to be compensated for its cost of housing this individual. $50 a day, that's $1,500 a month, so 30 days a month. Most people pay that and more in rent, and that's to say nothing about food, water, electric, other expenses. So your average Florida citizen spends a lot more than $50 a day. So while $400,000 for 22 years seems like a big number at the beginning, when you do the math, it's actually a very small number. Also, most of the case law cited by appellant, including the case he cited in supplemental authority, all of those involved a taking. They were a fine is a taking, like the. I'm going to mess up the pronunciation of the case, Your Honor, so please forgive me for that. But one that starts with the United States versus Bajakaljan. That case, someone failed to disclose amounts of cash he was carrying with him when leaving the country to the IRS. So that money was forfeited. It was taken from him. The case just recently cited by appellant in his supplemental authority was involving a tax sale where the state of Minnesota, I believe, decided to keep the excess money from the tax sale. All of those involve a seizing, a taking of something that the defendant already owned. That didn't happen here. This is simply a lien. It says, listen, you're going to be charged $50 a day and it's going to be X number of dollars. There's been no garnishment of his account. He doesn't have any real property that was taken from him. His bank account wasn't taken from him. His car, if he owned one, wasn't taken from him. So this is not a fine, so we don't get to the fine analysis. Regarding constitutionality, for something to be unconstitutional on its face, first of all, there's a very heavy burden that a statute is constitutional, but also, the appellant must prove that there are no circumstances under which this statute would be constitutional. Yet appellant's argument goes straight into the argument that the court should have considered his unique circumstances, which cuts against that argument. As soon as you're arguing unique circumstances, you've basically waived the unconstitutional on its face argument. And, Your Honor, as I mentioned earlier, I don't like to talk just for talking, so I've made the points I wish to make. If the court has any further questions for me, then the state will rest on its brief, and I would ask Your Honor to please affirm the judgment below in all aspects. Thank you.
Thank you, Your Honor. The first point is that counsel cited the Fort Lauderdale case as saying that that addressed the issue in this case. Not only was that case pre-Bajikican, that case preceded the Supreme Court's ruling on the federal issue of excessive fines. So it did not apply the U.S. Supreme Court's excessive fines analysis. Second, and if you look, I pulled both the court below, which is the DCA, as well as the Supreme Court, they do not address the excessive fines argument. These were based on equal protection, due process, substantive due process, and as you know, Justice Thomas is very much against substantive due process. He says it comes from the Privileges and Immunity Clause, and this is an excessive fines, which is an explicit guarantee under the Constitution that our citizens are to be protected against excessive fines. And his analysis is not incorporated by the Fort Lauderdale, so it has not been decided by this court.
What about the argument we just heard from Ms. Caldwell, that by virtue of you saying we need to look at the unique circumstances of this case, that eviscerates the facial challenge? Because as I understand it, the facial challenge, constitutional challenge, it has to be unconstitutional in all circumstances.
Well, there's two, that's why I split it into 2 points.
So the answer to my question is yes, that goes away?
Well, that's point 4. Okay, I'm arguing point 3.
Okay.
All right, and point four, I would say is the problem is the statute is fundamentally flawed because under the Tibbs case, it requires a proportionality analysis. This is a strict $50 flat fee, no proportionality analysis, and in fact, Blackstone even talks about this again in that not only does proportionality need to go to the case, it also needs to go to the individual, and because the statute does not have a proportionality analysis under either of those prongs, it fails on its face. So because there's no proportionality analysis, but that's...
So are you suggesting that courts and the government must take into account a person's financial ability to pay in determining an amount to be declared as liquidated damages?
I'm not suggesting that. Blackstone is. And I'm saying that because proportionality should be part of the statute under Blackstone and under the case called Tibbs, which is explained in point 4. But I wanted to focus on point 3 because I think that in my case, my individual case, it's clearly an excessive fine. And I wanted to, excuse me, I mentioned this, the Knoll v. State case, Florida Supreme Court 2016, cited in footnote 4 of the brief. It says, more causeless incarceration is deemed restitution to the state, which was conceded, for having to incarcerate the offender. The purpose of restitution is not only to compensate the victim, but also to serve the rehabilitative, deterrent, and retributive goals of the criminal justice system. It's only imposed on the finding of criminal justice. It is designed in part to punish, and it has to be a pure non-punishment statute in order to escape the excessive fines analysis. There is at least part based on Knoll and based on the advisory opinion of the governor cited in footnote 6. This is a fine. So, and you know, I think that we kind of get too tricky sometimes with our, you know, we're lawyers and we play with words. The reality of this is it's a fine. It's, you know, and they say, well, he's not been garnished. He's going to have canteen in his jail. That is going to be garnished. The fact that, well, it's just a judgment. Well, that goes to all fines. All fines are going to be penal against us. The fact that we don't have property, the part that is so crushing that you'll never escape it, that goes to the excessiveness. So, you know, as this applied in point 3, this is an excessive fine under the Constitution. I also wanted to quote the brief of appellee's brief on page 6, when we talked about the instruction. Your Honor asked about the counsel about the instruction, whether he could modify the condition of probation. And on page 6 in the answer brief, regarding Halloween, officer testified that she specifically instructed appellant that he was, quote, not allowed to participate in any Halloween activities, which is including dressing up and passing out candy and no lights at the residence. So we have, he was dressing up, but there's in the testimony that the officer said that the instruction was dressing up and candy and residence. He wasn't doing those second two things. So
if he were dressing up, passing out candy, but kept his lights off, he would not allow it.
Well, the idea is it doesn't appeal to children. The idea here is to protect children from a sex offender, right?
No, I understand, but I'm trying to follow the logical force of the argument. Your argument is you have to violate all 3 aspects of the portions you just quoted on page 6 in order to be deemed violating probation. Did I hear you correctly?
Well, under the way that this testimony played out in this case, but there was no that was never at issue because he wasn't at home, he was at work.
I grant that.
Yeah, and so, I mean, obviously, you know, passing out candy, you turn off your lights, you know, having participated in Halloween, you turn off your lights, people don't come to your door. You turn on the lights, that invites children of the neighborhood to come to your door, you pass out the candy. That's the tradition. So any other questions? Thank you very much for the opportunity of this beautiful courthouse.
It is a beautiful courthouse. Thank you both. Again, it was well presented on both sides. It is, according to my iPad, 11:11. So we will be in recess until 11:40. I believe that's the time of our next formal